You're watching Salina Media Connection. Philip Michael, an Assistant Attorney General for the state of Kansas, gave a presentation in Salina on 2 state laws that protect the public's access to government meetings and government records. Michael's presentation covered the Kansas Open Meetings Act and the Kansas Open Records Act.
Kansas Open Records Act. So this is going to be KSA 45215 at SEC. Same kind of deal. A lot of the issues that I hear about are related, of course, to the calculation and explanation of reasonable fees and costs. Anytime you have money exchanging hands, there's that potential for conflict. It just is. Oftentimes the records provided, not oftentimes, sometimes the records provided do not meet the requester's expectations. You find this is probably a communication issue. Either the requester didn't clearly state what they wanted or make it clear to the agency what they wanted, or the agency did not understand what the requester was trying to ask for. So like I said, sometimes that's just a communication issue, a misunderstanding. Sometimes a requester might believe there should be a record that exists, but there just simply aren't any. Sometimes agencies have not created a record that meets what the requester is asking for. And we'll talk a little bit more about this in a second, but an agency is not required to create a brand new record when somebody makes an open records request. If it isn't a record that an agency already possesses, then they don't have to create it specifically to fill the request. Is an agency or entity covered by the KORA? And if not, why not? Similar kind of thing is an entity subject to the Open Records Act, the same as they would be subject to the Open Meetings Act. The simple stuff: failure to respond within 3 business days. We'll talk about it. Failure to provide requested records at all. And criminal investigation records are always an area of potential conflict. So we'll talk about the KORA the same way we kind of talked about the KOMA. So what is the point of the KORA? So public records shall be open for inspection by any person unless otherwise provided. This act is going to be liberally construed towards openness. It's going to be applied accordingly. So any exception to open needs to be very narrowly tailored and is going to be very narrowly scrutinized in any enforcement action. So the KORA was enacted in 1984. It replaced the Public Records Inspection Act in 1957. So what the KORA did, the Public Records Inspection Act from 1957 stated that a public agency only had to provide those records that they were statutorily required to create. The KORA expanded that significantly. But with both of these laws, both the KOMA and the KORA, I want you to keep in mind, one was written in the 70s, one was written in the 80s. Most of the language is still native to those 2 decades. So we have an 8-track law, we have a cassette tape law, we now live in a digital cloud world. So sometimes the language doesn't always fit, so we have to try to make it work. So, what's a public record? It's any recorded information, regardless of form, characteristics, or location, which is made, maintained, or kept by or is in the possession of either any public agency or any officer or employee of a public agency pursuant to that officer or employee's official duties. There's a couple things here. I think you'll notice, hopefully, that or location is in bold. So this was a change that was made a few years ago. So this is going to expand the idea of it doesn't have to simply be on a government-owned device or on a government-controlled email account. So this, as I said, location is relevant. It could be paper, it could be electronic, it could be official email, it could be private email, it could be a social media account, it could be on a private device, computer, or private laptop, private tablet, private cell phone. So if any government employee is doing their public work on a private device, that is both going to be potentially discoverable in a court action and potentially subject to the Open Records Act if that's where that record exists. My agency has very strict policies about the use of private devices and private email accounts for that very reason. Some poor person like me I serve as my agency's Open Records officer as well, is going to have to review those private emails to find a public record, and nobody wants to do that. I don't want to do that. Yes, sir.
As a public employee, like I down here, if I'm taking copious notes, are those notes subject to open records?
Notes are going to be an exception to open records, which we'll cover here shortly. But one of the exceptions to open records deals with notes and drafts specifically. So your private notes are exactly that. That's probably something that would be discretionarily closed if somebody made a records request for it. Yes, ma'am.
So as an elected official, and this is what I have been assuming, I don't know if it's correct, should I assume that any communication that comes to me from the city and any response that I make to that city employee would be discoverable if an open records request were made?
Quite potentially.
Okay.
There is a little caveat there, which I'm going to talk about on this slide, that involves your specific situation. So, a public record is not going to include those records which are owned by a private person or entity and not related to the functions, activities, programs, or operations funded by public funds. So, you can't make an open records request of a private company wanting their records the same way you can ask a government agency for theirs. So I want you to also keep in mind, for our purposes here, a private person is never going to include an officer or employee of a public agency who is acting pursuant to that officer or employee's official duties. However, records made, maintained, or kept by an individual who is a member of the legislature or of a governing body of any political or taxing subdivision of the state is not going to be considered a public record there. However, when you discuss that communication you make with an employee of the city is potentially open on their end, because they are an employee during the normal course of business. So, records not yet in existence at the time of the request, those aren't public records. Like I said, an agency does not have to create a new record to fill a request. If it's not something that exists, it's not a record they can provide, or have to provide, I should say.
If I might ask, back one step,
This
the records made, maintained, or kept by an individual as a member of the governing body, would that cover correspondence between a governing body member and a member of the public?
Well, that member of the public would have the right to release anything they want.
Right. But in terms of having the request made by a third party alleging it's a public record, is that considered a public record?
Unless it is possessed by an employee of that agency, then that is potentially not a public record. Yes, sir.
Is there a very good test to determine when a record exists versus when it has to be created?
Help me with context there.
We frequently get requests from property owners or pending purchasers or whatever for a zoning confirmation letter. There's no ready-made, already made-up letter for that property. We have to do research and create a letter to satisfy the lender or prospective purchaser. We always respond to those requests, but would that come under the category of a created record versus a record that exists?
I would struggle to say that qualifies as a KORA request, necessarily. Is that how you're treating? Are you treating those as KORA requests?
Well, that is the way a lot of those individuals are submitting their request to our office, is as a KORA request.
Certainly. But as I said, under the law, if it's a record that does not already exist, you potentially don't have to provide it that way. Now, whether or not there is another document or a record that they can ask for that has that information, I do not know. And if there isn't, that might be another consideration you have to take into account.
We always respond, but we're never quite sure if it falls within the KORA.
It doesn't comfortably fall within the KORA, I don't think. But it might not comfortably fall anywhere else either. So it may be your judgment call. So, we talked a little about what a record is. So what is a public agency? This is going to look a whole lot like KONA. So the state, any political or taxing subdivision of the state, or any office, agency, or instrumentality thereof. So we don't use subordinate group or KORA, we use instrumentality. It is also not defined in statute. So kind of the same analysis. I want you to think of how it functions, who created it. And if the answer to that is it functions as a government agency or it was created by a covered entity, then it's very likely that that instrumentality's records are going to be determined to be public records as well. So, private companies are generally not going to be considered a public agency for our purposes here. Even if they receive funds in exchange for goods or services, that could just simply be they have a contract with the city or a contract with the county. Municipal or state judges and justices are not going to be considered a public agency for our purposes here either. The KORA does apply to court records. However, the KORA allows, as I said, the judicial branch to make its rules via Supreme Court rule on how it handles those requests. So, what the KORA really is this procedural statute. It tells members of the public how they can make a request. It tells an agency how they have to respond, when they have to respond, what they can redact, what they can accept from providing. So really kind of the best way to talk about this is what the process has to be, the procedure that's necessary. So what a public agency has to do under the KORA, they have to appoint a Freedom of Information officer to assist with KORA requests. They have to display, distribute, or otherwise make available a brochure describing a requester's rights, the public agency responsibilities, and the procedures for requesting or obtaining copies of public records. Keep in mind, 1980s language, a lot of entities do a brochure as something on their website. We have an online policy on our website, is our brochure, that defines a fee structure. It talks about hours, etc. It fulfills that need. So you have to have the name and title of the records custodian. You have to have your fees. You have to have office hours available for anyone to make a request. Normal KORA office hours are 8 to 5, Monday through Friday, business days. So, who can make a request? In Kansas, any person may make a request. They don't have to be a citizen of the state of Kansas. The reason to bring this up is some states don't extend it that far. Some states limit requests to citizens of that state only. For instance, the Commonwealth of Virginia has limited all records requests made to any entity in the Commonwealth of Virginia to citizens of the Commonwealth of Virginia. That's been upheld as far as the Supreme Court level. Also, keep in mind that a person, whenever they make a request to your agency or to an agency, they don't have to provide a reason for their request. And more specifically, you're not really allowed to ask them, why do you want that? You might have to ask them for clarification so you can understand what they're looking for, but you can't demand to know why do you want that record. So, what can a public agency require? They can require all requests to be in writing. And any of you that work for a public agency and you don't request these to be in writing, I would ask you to reconsider. It eliminates the he said, she said, back and forth. You can require the requester's name and address. You can also request proof of identification. You can also ask for a written certification that the requester will not use names and addresses obtained from the records to solicit sales or services. It's not a complete ban on economic activity, just the solicitation of sales or services from lists of names and addresses. So, rights of the requester. Unless closed by law, the public has a right to review all public records, almost without exception, almost. So any person can make abstracts or request copies of records. If an agency doesn't have the ability to make a copy of the record, they have to allow the requester to make arrangements to make those copies. An example of that is, I want you to think of an agency that might have very large maps. They may not have the ability to scan or copy those in-house, but they do have to, if somebody really requests, help that person find a way to make those copies. That doesn't mean the agency has to bear the expense, they just have to make that record available for the copy. Also do keep in mind that if a portion of a record needs to be closed or redacted, the remainder of that record needs to be provided to the requester. Simply because a portion of a record is subject to some of the exceptions we're going to talk about doesn't mean the entire record falls under that. So, there are some limitations on requester's rights. A requester may not remove a public record from your premises, from a government premises, without the written consent of the custodian. Also, a public agency is not required to make copies of radio or recording tapes or discs, videotapes, or films, pictures, slides, graphics, illustrations, etc., unless they're shown at a public meeting. In addition, a public agency does not have to make copies of copyrighted materials without the permission of the copyright holder. But if somebody really wants to come into your public agency and listen to that Metallica CD, you have to let them listen to it, but you don't got to make a copy of it for them. So, I talked about the process. So, when a public agency receives a request, it has to be acted upon as soon as possible, but not later than the end of the 3rd business day following the date the request is received, which we'll discuss just a little bit here in a second. And by the end of that 3rd business day, there are 3 acceptable responses that an agency can provide. One is the record is provided in the form requested if possible. It's honestly the best outcome for everybody. The requester gets the record they want, the public agency gets to close the request and move on. The second step is the intermediate step. This is the request is under review, and the records if permitted will follow. So this is where an agency can ask for clarification. This is where an agency can ask for advance payment of fees. And the third option, the third possibility is that the request is denied. Now, if the requester asks, an agency has to provide a detailed explanation for the reasons of denial. So, I mentioned those 3 business days. This is simply a calendar of July 2019. So, as I said, business days, business hours. So business days are Monday through Friday, 8 to 5, unless you've said something else. It is going to exclude holidays, it's going to exclude weekends. So, on this calendar here, a public agency receives a records request on Tuesday, July the 2nd at 9:30 a.m. When do they have to send, at the very latest, a 3-day response back to the requester? So, we'll step through. So as I said, they received on the 2nd at 9:30 a.m., so that's going to be during normal business hours. So you're going to start counting on the 3rd. So the 3rd's going to be 1. We don't count the 4th because it was a holiday. 5th is 2. We don't count the 6th and the 7th because they're weekend days. So they're required to send out a response on the 8th of July. Similarly, say that request that came in on the 2nd didn't come in until 6:30 p.m. Now we're talking about having to send out a response on the 9th because it was not technically received until that next business day, the 3rd. Like I said, this is not a real complicated process, but it is an easy one to mess up. All it takes is misreading an AM versus a PM on an email, and you may be a day off in your calculation. I've gotten a lot of phone calls from local governments that stated, I just misread the date. Meant to send it by 3, it took 4 days instead. That kind of thing. So like I said, while simple, it is easy to mess up. So, I'm going to give you another example. This is also from enforcement action on our website. You can take a look at it if you want. So, a KORA request was submitted to a police department. The records clerk was directed to not fulfill the request until they were advised to do so. The problem is they were not advised to do so for 53 days. During the course of that 53 days, the requester followed up multiple times by email and phone and received no response. They didn't receive a 3-day response, didn't receive any kind of response. At the end of that 53-day period I talked about, they were provided with 1-page of records. So it's going to be a violation of the KORA. Like I told you, these are usually going to be pretty easy. So yes, this was a KORA violation. The public agency possessed records that were responsive to the request. They failed to respond within 3 business days. In fact, they didn't respond for 53 days. There was a discretionary exemption to disclosure that would have eliminated the need to provide most of those records, frankly, but they didn't even get that far. The penalty that these folks had to pay is 1 hour of KORA training for all staff that was responsible for KORA compliance, a civil penalty of $100 paid by the agency, and they had to agree not to engage in any further violations. So, as I said, the examples kind of lead to why we talk about penalties, and then we'll move on to how not to get in trouble again. So, the penalties available under the KORA are going to look very similar to the penalties available under KOMA, with one very specific difference. There's a civil penalty of up to $500 for each violation. This is paid by the public agency, not by the individual. There's required completion of Attorney General training. It can be orders to cease and desist from further violations. You have to agree to comply with the KORA. You can also pay those reasonable expenses, investigation costs, and attorney's fees. Those are the penalties available under KORA. So, the biggest source of complaints I receive over the phone or when I talk to people in person are going to be about allowable fees and charges. Keep in mind, a public agency may only recover the actual costs necessary to provide the requested records. It's not meant to pay for costs that would have otherwise been incurred by the agency anyway. It's not meant to pay for capital improvements, utilities, rent, overhead. It's not meant to pay for your employees' overtime if your agency has chosen to assign fulfilling that KORA request to an employee on overtime status. Those costs that you can charge, that a public agency can charge, include staff time to retrieve, review, and redact information from a record. Fees can be estimated and collected before the records are provided. You can ask for prepayment of fees. My agency does, because we get a lot of very large requests, and those could be hundreds of hours of somebody's time. And if we don't seek prepayment of fee, we may never get that money, and we might be out hundreds of hours of somebody's time. Yes, sir.
The example you gave just a minute ago, the 53 days,
Yes.
they made the initial request and then they followed up several times. Are those treated as separate requests there
No.
or occurrences?
I would not say so. They made the initial request, and they never received any response at all to their initial request. All their follow-ups were still about that first request. It was just never fulfilled. So none of those would serve to be a brand new request, I don't think. So there are two main reasons why records might be closed. One is going to be mandatory, which we'll talk about here in a bit, and the other one's going to be discretionary, policy reasons why a record may be closed. So these are going to fall into three large buckets. So personal privacy, safety/security, and internal communications. So we'll talk a little bit about personal privacy first. So medical, psychiatric, psychological, or alcoholism/drug dependency treatment records pertaining to identifiable patients do not have to be released under the KORA. There is a specific exception to that. Personnel records. Performance ratings, individually identifiable records pertaining to employees or applicants. So we need to think of what might be in a personnel record. It could have resumes, references, discipline, family information, social security numbers, personal addresses, contact information, phone numbers, any salary deductions you might have, photos, medical information, etc. So all that stuff can be in an employee's personnel file. All that the KORA requires you to release are the names of employees, the positions/titles of those employees, the salaries or actual employment contracts of those employees, and lengths of service. I once worked for the Department of Administration, and one of their primary functions was the State Office of Personnel Services. So every year we filled multiple requests for the salaries of all state employees across the state of Kansas. Those categories I just told you are the categories that we would provide. So still talking about personal privacy. So if something is clearly unwarranted invasion of personal privacy, that record can be discretionarily closed. When you think of information that's highly offensive to a reasonable person, that's that standard. So think of your mother's maiden name, your date of birth, your street address, phone number, bank account information. Anything like that can be discretionarily closed as personal privacy, unwarranted invasion of personal privacy. So the KORA allows for this, I don't want to call it secrecy, but it allows a large amount of protection to concealed carry permittees. So records that would disclose the name, home address, email address, phone number, cell phone number, or other contact information for concealed carry licensees, applicants, or persons enrolled or have completed weapons training, it's closed unless it states otherwise in law. So I want you to keep in mind the Attorney General is the official custodian of all records relating to the licenses issued in accordance with the Personal and Family Protection Act, the PFPA. So my agency is the official custodian of those records, but the KORA does not allow much leeway in providing those records out. So the next big bucket is going to be safety and security. So there's a lot of exceptions under safety and security that protect law enforcement and emergency information. So records that would reveal the identity of an undercover agent or any informant reporting a specific violation of law can be discretionarily closed. So records concerning emergency or security information or procedures of a public agency, if that release would jeopardize the security of the public agency, those records can be withheld. And as we're talking about that, I want you to think of plans, drawings, specifications, or information related to any building or facility which is used for purposes requiring security measures in or around the building, or if the facility is a public utility, for instance. We've refused to provide, we've received records requests, for instance, somebody asked for the wiring diagram of Lansing Prison. It's definitely a building that requires security measures. Providing the wiring diagram, which this was a public bid, it was a public bid to redo the wiring system on their security system specifically. You can understand why those records might not be best released to the public. So, still talking about safety and security. Information that will reveal the location of a safe house or shelter for abused persons, or the name, address, location, or other contact information of alleged victims of stalking, domestic violence, or sexual assault. Those records do not have to be provided.
Question.
Yes, sir.
If you just get a call from somebody, and this actually happened to me in a previous city, guy on the phone says, I'm looking for, Jane Doe. And I talked to him for a little bit, and he says, well, I know she lives in your city, and I just got out of prison, but I need to know her address. I need to know her address off your utility system. Are you required to disclose that?
You are not.
Okay, thank you.
There are great protections under the KORA for the billing records, the information to utility customers. So you're absolutely within your discretion to not provide
On a
those
single
kind of
customer,
records.
I know you don't have to release lists.
Right.
Okay,
Extend it,
okay.
theoretically. Because I neglected to mention that the whole point here is I'm not allowed to give you legal advice. We're allowed to talk about what the law says. What the law says is there are great protections to utility customers under the Open Records Act. So we have a couple slides here that kind of work together. So records of a public agency on a public website which are searchable by a keyword search and that identify the home address or home ownership of a law enforcement officer or parole, probation, court services, or community correctional services officer. It's a whole lot to say, but think of your county appraiser's website or any other thing where, any other website where somebody can search by property. So if that individual officer wants, they can file a request to restrict that identifying information from public access on that website. Once they file that request with, say, the county appraiser, the county appraiser would then have the duty within 10 days of receiving that request to remove that identifying information from their website. The request is good for 5 years after it's made, and it can be renewed thereafter. And I said that slide and this slide go together. This one covers judges, Supreme Court justices, Court of Appeals judges, district judges, magistrate judges, U.S. attorneys, assistant U.S. attorneys, etc. It also includes assistant attorney generals and the like. So I fall under this category. If I so chose, I could have my home address removed from that public website as well. I work in an agency that sometimes deals with people that maybe it's best if you don't know where you live, for good and bad. So, criminal investigation records, it's always one of the big topics. It's always one of the ones that can be the most contentious. So, what is a criminal investigation record? It's a couple big buckets now. Recently, the legislature passed this. So every audio or video recording made or maintained by law enforcement using a body camera or vehicle camera is going to be a criminal investigation record. Also, it's records of an investigatory agency or criminal justice agency that's compiled in the process of preventing, detecting, or investigating violations of criminal law. So those are the two big categories, and we'll talk about them a little bit here. So when we talk about criminal investigation records, what are we talking about? I want you to think of your standard arrest reports, mug shots, breath test results, coroner reports, filed as part of a criminal investigation. Or some examples. So, the audio or video recording made or retained by law enforcement using a body camera or vehicle camera can be released to this following categories of people. The subject of the recording, the parent or the legal guardian of the subject if they're under 18 years of age, the heir at law of a decedent who is the subject of the recording, or the attorney for any of those above entities. So law enforcement has to provide access to those individuals, but they can't charge a reasonable fee for making that video or audio recording available. So, it's a long list of things that are not going to be considered criminal investigation records, from police blotter entries, wanted posters, court records of public proceedings, inmate rosters, violations of traffic law other than vehicular homicide, and the front page of the standard offense report, or the SOR. But you can't redact certain information off of the KSOR. You can redact the identifying information of victims of a sexual offense, for instance. Also, if it's a clearly unwarranted invasion of personal privacy, you might think about street addresses and the like as well. So, in an action brought under the KORA to force release of criminal investigation records, the district court is going to look at these factors to determine whether or not a record should be released, even if it's a criminal investigation record. They're going to look at if it's in the public interest. And I don't just mean curiosity, I mean, is it in the interest of the public? They're going to look at, would it interfere with any prospective law enforcement action, criminal investigation, or prosecution? Would it reveal the identity of any confidential source or undercover agent? Would it endanger the life, physical safety of any person? And also, would it reveal the name, address, phone number, or other information which specifically identify a victim of sexual abuse or assault?
Question.
Yes, sir.
If we're not allowed to ask why they're asking for the record, how do you determine if it's mere curiosity?
Sorry, how do you determine if it's mere curiosity?
If we can't ask what you want these records for, how are we supposed to determine if it's mere curiosity or not?
So, under the law, when we talk about the in the public interest, when I say it's not, it's more than mere curiosity. Is it in the interest of the public? Is it for the good of the public to release that record? Not is it just I'm curious and I want to know. But like you said, you can't ask them why. So it's going to have to be within your judgment to determine whether or not that record is something you should release. And if the answer is no, and you do decline to release something pursuant to that exception, you cite to whichever ones of those subsections you determine apply here.
But mere curiosity is not one of those subsections.
No. Is it in the public interest is one of those subsections. So, a couple other issues when we talk about criminal investigation records. Victims and defendants generally under the KORA don't have a special status to receive records. And also criminal investigation records don't necessarily become open if criminal charges are never filed. There might still be discretionary closure that may exist. So the last big bucket of discretionary closure that we would talk about are going to be those internal communications. So records privileged under the rules of evidence unless there's consent. So think of attorney-client privilege. Records of an investigation conducted under civil litigation or administrative adjudication. So it's going to be civil service board hearings and the like. Our KORA and KOMA enforcement actions are conducted under civil litigation, administrative adjudication. So correspondence between a public agency and a private individual, unless it's intended to give notice of an official action, can also be discretionarily closed. So, and I know that we talked about this a little bit earlier, but notes, preliminary drafts, research data in the process of analysis, unfunded grant proposals, memoranda, recommendations, or other records in which opinions are expressed or policies or actions are proposed, except where those records are publicly cited / identified in an open meeting or in an agenda of an open meeting. So your notes that we talked about, those can fall under this exception if somebody were to ask for them. Unless you go to your board meeting and you start reading from them or talk about them or reference to them. That is an area in which the coma might override the KORA, for instance. So attorney work product also would be discretionarily closed. So procurements and bids. So appraisals, engineering or feasibility estimates, evaluations by or for a public agency relating to the acquisition or disposal of property prior to the award of formal contracts don't have to be released. Specifications for competitive bids until they've been officially approved by a public agency do not have to be released. Similarly, sealed bids and related documents until either a bid is accepted or all bids are rejected do not have to be released. So that is not nearly all of the discretionary closure ones. I didn't figure that you all wanted me to go through all 55 or so that exist just in that one. And some of them really are not all that fascinating, talking about library patron records and the like. In addition to discretionary closure, there's mandatory closure of records that might impact whether or not somebody can receive a record. So these are going to be records that are required to be closed by a federal or state statute that's not found in the KORA. The KORA is going to look at these other statutes first. It's going to subordinate itself to a specific law prohibiting disclosure. So criminal history record information does not have to be released. SINC or child and native care records, trade secrets, industrial processes, student data, FERPA records, social security numbers, and the like. So there are certain statutes or federal laws that might mandate closure of something that's not specifically discussed in the Open Records Act. So, search and arrest warrants. Currently, any person can file a request with the clerk of the court to see the affidavits or sworn testimony attached to a search or arrest warrant. When the clerk receives a request, they have to promptly notify the defendant, the defendant's counsel, prosecutor, and the magistrate where the request was filed. The prosecutor then has some obligations to notify the victim or the victim's family if necessary. The magistrate, when reviewing this request to determine whether or not to release those affidavits and sworn testimony, reviews a long list of factors, which I'm not going to read to you unless you really, really want me to. But the gist here is it going to jeopardize safety or interfere with the law enforcement action. You're going to endanger life or safety. So after the judge does that analysis, there's a couple different options here. The judge can order disclosure with appropriate redactions. The affidavit and the sworn testimony will then become part of the court record and will be accessible to the public as the person might request. Or the judge can determine that he's not going to make that publicly available. He can seal those affidavits and sworn testimony. They'll be part of the court record that is not accessible to the public. As part of this, any request for that disclosure is also going to become part of the court record and will be accessible to the public. So anybody who asks for the release of those affidavits and sworn testimony, their request becomes part of the record that is available to the public as well. So there is a penalty to unlawfully disclosing an arrest or search warrant. So make public that a warrant was applied for or issued, for instance. If you make public the content of the affidavit and sworn testimony, those are going to constitute criminal disclosure of an arrest warrant. It's a Class B non-person misdemeanor. That doesn't mean a law enforcement officer or a law enforcement agency can't disclose the content of a search or an arrest warrant. If it is to gain assistance in executing the warrant, if it's to encourage a person named in the warrant to voluntarily surrender, or if it's where a warrant is issued in the case surrounding the abduction of a child, unless there's specific reasons to not make that open. So, just mandatory closure of records, care, and treatment proceedings. So mentally ill persons' commitment and treatment records are going to be privileged and shall not be disclosed. However, release is possible with consent of the patient and former patient, legal guardian, etc. However, the head of the treatment facility may refuse to disclose portions of the records if it's injurious to the welfare of the patient or the former patient. So, KDHE, infectious and contagious disease reports. So, the agency can disclose if there's no identifiable information. The disclosure is for statistical purposes, or if identifiable persons consent in writing, or if it's necessary to protect the public health, or if it's a medical emergency. So, redaction. So, if you have a record that has some portion that needs to be redacted, either mandatorily or discretionarily, you redact that portion. You have to make the remainder of that record available to the public. The public agency is allowed to charge for the time that's necessary to do that redaction, either through the old school Sharpie marker or a computer program or whatever is necessary to accomplish that. Redaction is not denial. It is redacting portions of the record in accordance with the law as necessary. So, the Attorney General's website has, well, let me go back. Does anybody have any KORA specific questions or common questions? Yes, ma'am.
So if an individual is out of the office and receives a direct request for open records, when does the timeline start?
So, any employee of an agency can potentially receive an open records request. The KORA does not contemplate somebody being out of the office for vacation. I wish there was a better answer I could provide you. It's simply just not discussed in the law.
So when they make a KORA request, does there have to be something that specifies that I'm making a request under KORA? I mean, because somebody can get my email address off the website.
Sure.
It's brad.nelson. It's line of the word. If you get that, and then send me an email and ask a question, I might not realize whether that's a KORA request or not, and not respond in 3 days.
So certainly, there's not always magic language, so you kind of have to look for buzzwords. Copies, records, sometimes they cite the FOIA even though it's not going to apply necessarily to a state record. If they ask for information, it may not be. If they're simply asking you a question, it may not be. If they're not citing to KORA, if they're not stating I want a copy or I want a record, it might not be a records request in your understanding. And they may need to clarify that they are requesting a record in that case. So, but if doubt exists, and it's the policy that my agency follows, if there's doubt on whether or not it's a request or not, we try to treat it as a request when possible, just to cover our bases that way. But simply somebody sending you an email asking a question may not qualify as that. Yes, sir.
On the information that is personal in nature, does that become more open after that person is deceased?
Not necessarily. I don't know there's any magic language in the law that covers that. Yes, ma'am.
When a recording's made during like a committee meeting when votes are taken and everything, once the minutes for that meeting are accepted, are you still liable for holding on to that recording, or is it okay to delete it, or is there like a retention time?
So when we're talking about retention, that's going to be a little bit beyond our scope here for open records and open meetings. But retention, I don't know if you have a retention schedule for recordings, which is one of the topics that is becoming very prevalent now. The recordings are becoming a more common thing.
Someone asked me during one of our last meetings, and I was like, well, I haven't deleted any minutes.
So I don't know if you have a local schedule or not. What I will say is if you don't know and if you want to know, you might check with the folks at the State Historical Society, the archivists, because there's a state records board that governs retention schedules. I know them pretty well, but I don't know the schedules for the local for sure. I know that that is a topic that's becoming more prevalent around the state. Simply storage, how long you have to keep, and the like. There was a bill put in place, it was introduced in the last legislative session that would have required all government agencies in Kansas, so 3,793, to record and make available meeting recordings within 24 hours after a meeting. It made it to a committee hearing. It did not progress farther. I'm not making a statement one way or the other, but a lot of the criticism that happened of that bill related to the cost of storage and how realistic is it to make something available within 24 hours. But it still exists. It's still on the calendar for this year to potentially have action. So just something to keep in mind. Yes, sir.
Excuse me. If there's a request for all communications, including emails, between either agency and another agency or two persons, how much energy has to be expended to go back in an unknown period of time, or does that request have to be very specific, very narrow?
So this is one of those situations in which I would theoretically, if it is a really large bucket, for instance, somebody wants all communication with your agency and, I don't know, for instance, a company like Google, which, by the way, can be thousands. Perhaps you ask for clarification to see if they're willing to narrow it down to a specific time frame. But that's going to be up to you to determine. If you don't know how big the, what we call it, the universe of records are, then it's going to be hard to come up with a cost estimate and the like.
Or if they know what the topic, I'll just say between the city and the Chamber of Commerce. If they know the topic that they're interested in, they can even give a reasonable time frame, but it's going to be in years, not months. You're still looking potentially having to go through probably thousands or tens of thousands of emails individually to see which ones would be appropriate. Otherwise, you're just sending a whole bunch of communications that weren't related.
Yes, sir. But a public agency is allowed to charge for a reasonable time to provide those. So one can do a cost estimate that encompasses what your reasonable time is to ensure that you won't be doing that work for free, and to ensure that maybe they're getting the records they want as well. Yes?
If it's not reasonable to be able to estimate the cost, can you do it in agreed upon increments of funds deposited, do $100 worth of work, and then ask if they want you to continue, or do you have to have an all-inclusive estimate at the outset?
So for good or bad, what the KORA doesn't really do is set real strict limits on how you have to work that out. So if it is in your interest to have an arrangement like that with a requester, it's not specifically prohibited by law. Yes, sir.
Is there any mention of that, whoever can handle the task at the lowest cost, that you have to use those personnel, is that mentioned in the case?
So under the KORA, it doesn't really talk a whole lot about fees. I think what it specifically says is that 25 cents a page for paper copies is reasonable, but it doesn't go into a whole lot more detail than that.
That's on the hourly fee of the employee.
So the hourly fee of the employee, whenever you're coming up with your cost estimate, you have to come up with your actual costs.
Yeah.
So if you're talking about the lowest wage of the first qualified person that can do that,
That can perform that task. Yeah.
it's not specific to the law.
Where the state I came from it was, but there were also issues with, sometimes you didn't want that person going through, for example, the email. You don't want that going through another person's email.
Right.
And that became an issue there.
That topic has been also presented in bills that have not passed all the way through the legislature as well to set very specific structure for fees, but it's not been completely passed through or implemented here yet. Anybody else for KORA specific stuff? Okay. So I was going to tell you a little bit about our website, and then I'm going to let you all go. So the Attorney General's website, ag.ks.gov, we have a tab for open government, which you can see in my nice circled. So under that tab for open government, we have resources, for instance. So if you want to see what our records policy looks like, if you want an example of one that hasn't been struck down, for instance. We have some training slides. We have the Citizen's Guide to KORA and COMA, so it's going to be the basic overview document. We also have the ways for a citizen or anybody else to file a KORA or COMA complaint. Instructions online, as well as a way to file that complaint with us. Anybody who wants to file a KORA or COMA complaint in Kansas can file a complaint either with the Attorney General's office, or their county and district attorney in their county group. So there's concurrent jurisdiction there, so you can file with either. So we also have a listing of our enforcement actions. That's where some of those examples come from. If anybody really wants to look at how other people have violated the law so that they don't repeat, then those are on our website as well. So, a few additional resources. Washburn Law hosts all of the Attorney General opinions dating back into the 70s. So that's my presentation for today. Does anybody have any other questions? Well, with that, I'm going to let you all go.
That was a presentation by Kansas Assistant Attorney General Philip Michael on the Kansas Open Meetings Act and the Kansas Open Records Act. You're watching Salina Media Connection.